Hi, everyone. Beth Steltzer here from Save Women's Sports. I have a treat for you tonight. This morning, we got to listen to a hearing of the Soule case, and we are lucky enough to have lawyer and feminist Kara Dansky with us. Kara, can you introduce yourself to us?
Sure, and thanks so much for having me. So, as Beth said, I'm a lawyer and a feminist. I'm currently serving on the steering committee of the US chapter of the Women's Human Rights Campaign. And I was there for the almost 2.5 hour hearing that took place this morning. So I'm really happy to be here to talk about it.
Thank you. I think it'll be great for our audience to learn more of the basics and just what we heard today. I know I was there too, and it was kind of shocking for me to see. It seemed pretty like a David and Goliath battle. There were quite a few lawyers in there for the opposition. What are your thoughts?
Yeah, so let's get right into it because that's actually where I wanted to start. I'm going to just give some sort of overview so that everybody understands what's going on in this case and why it's so important. But I'll do it really briefly, and I'm not going to go into excruciating detail like they did during the hearing this morning because I don't know that that would be helpful. I'm going to break it down and make it as simple as I can. So I thought I would start with exactly what Beth just pointed at, which is who are the players involved and what are they asking for? And then the second thing I'll do is talk about the events that led up to today's hearing. And then the third thing is I'll say a few things about today's hearing and what we can expect next. And then if we want to go into a conversation about upcoming events or how this case might relate to the Biden executive order or the Equality Act, we could do that too, if you'd like to do that, Beth.
Sounds great. Yeah, let's dig right in.
Okay, awesome. So who are the players involved in this case and what are they asking for? First of all, the plaintiffs. These are 4 girls. They're all athletes in Connecticut, although one of them is now in college somewhere else in South Carolina. These 4 girls are named Selena, Chelsea, Alana, and Ashley. I think most of your listeners probably know that. And they have filed a complaint. And what they are asking for is a ruling from the court that allowing boys to compete on girls' teams discriminates against girls in violation of Title IX. Their complaint and their ask is pretty straightforward. They're asking for money in the form of damages and attorney's fees. They're asking the court to have Connecticut stop the policy of letting boys compete on girls' teams. And they're also asking for schools to go back and for the state to go back and correct records so that when boys are recorded as having won competitions, these girls are asking the state to correct that.
Yeah. So very important. I cannot imagine future generation of girls looking at records going, why can't I beat it? Not knowing that it was a male body that said it.
Yeah. So those are the 3 specific things that the plaintiffs are asking for. Now, the defendants in this case, and this is where things get a little complicated, the defendants are the State Athletic Association, a handful of individual schools and school districts, and the interveners. I'll say a little bit about what that means. But basically, what the defendants are asking for in this case, and this is why it gets a little confusing, because they're not all asking for the same thing. The interveners in this case are 2 boys who were permitted to compete on the girls' track team. They were not initially defendants in the case. They asked to be brought in as defendants in the case, and their request was granted. They want complete dismissal of the girls' complaint. They do not want the state to have to stop the policy. In other words, they want the state to continue to let boys to compete as girls, and they do not want the state to go back and correct records. The Athletic Association wants the same thing. They essentially want the entire complaint dismissed with and can continue allow boys to compete on the girls' teams and not to correct the records. So those are the things that are being asked for. And the reason that matters is that anybody who watched the hearing this morning may have been confused because the defendants did not all seem to be on the same page. The reason for that is that for the most part, as far as I could tell, the individual schools and school districts didn't spend a lot of time arguing today about the underlying complaint. Instead, they just want to be released as defendants. In other words, they don't want to be held accountable for any of this stuff. That seems to be their primary motivation. Okay, so the events leading up to today's hearing, just so everyone understands where this case is, these girls filed an administrative complaint before the Department of Education back in June of 2019. It didn't go very far. And by February of 2020, they'd sort of run out of patience with the Department of Education. So they filed a complaint in federal district court. So this is a different thing. Their first complaint was with the Department of Education. The current complaint that we're talking about is a legal complaint in federal district court.
I think that gets a little confusing. It's great for you to clarify that.
I know, it really does. And their complaint was only against the state athletic association and the school district. So at some point, these defendant interveners moved to intervene as parties. These are the boys who competed as girls under the state policy. And during a hearing on that motion, this is ancient history, but it's important that everyone understand. During a hearing on that motion, the judge ordered the girls' lawyer to refer to these boys as, quote, transgender females. So the
compelled speech.
Compelled speech and speech that goes, you know, it's totally counter to what these girls think and what their attorneys think. So they moved to have the judge disqualify himself because of what for most of us will seem like obvious bias against the girl athletes. He denied that motion to have himself disqualified. Of course he did. And then the denial of the motion was affirmed on appeal. So today's hearing went before that very same judge, the very same judge who told the girl's lawyer to refer to boys as transgender females, heard today's hearing. So the defendants ultimately filed a motion to dismiss the complaint, and today's hearing was for both sides to argue, for the defendants to argue in favor of dismissal of the complaint, and for the plaintiffs to argue against it. So a few things about today's hearing that I will just share. The attorneys for the interveners went first, arguing that Title IX permits the state of Connecticut to let boys who this attorney referred to as girls who are trans to participate in girls' sports. Now, it's interesting to me that the attorney for the interveners was permitted to go first because, again, these interveners are boys. They are represented by the ACLU. They were not originally parties in the case at all, and they asked to be brought in. They're not even the primary defendants, and yet the judge let them go first. Interestingly, though, to me, listening to this lawyer argue on behalf of the boys, it was just interesting to me. He repeatedly used the word girls when what he meant was in his language, right? In trans language, he meant cis girls, but he messed up. He just referred to girls as girls, which we all know is the truth. So that was interesting to me. He also repeatedly used the word sex and the phrase sex segregated sports, because at the end of the day, we all know what these words mean. I think that was just a slip up on his part. He also said toward the end of his remarks, quote, "There's room for everyone on the playing field." Okay, the attorney for the Athletic Association went next. She explained that the original purpose of the Athletic Association's policy is inclusion. And she said that because Title IX is about empowering young women, the state's policy furthers that goal. We know that that's not true. She said that the plaintiff girl athletes have provided no proof of future harm to girls, which is of course true, but how on earth could they prove future harm? That's not the legal standard at all. She said that this case is not about an individual's right to win, which is also true, but that's not the point. She also said that it's not appropriate to correct previous records because the Athletic Association had not been given notice of the plaintiff's argument. And that becomes relevant for reasons I'll explain. The attorneys for the schools, as I said, the attorney for the schools and school districts basically argued that, that they should be exempt from liability, in part because they don't control the CAIC policy, and in part for reasons that get into technicalities that I don't need to go into. And then Roger Brooks from ADF went, and I don't want to say too much about what Roger had to say, other than to say that he did a fantastic job. As Beth said, he was up against 4 different attorneys, and he just took their arguments one by one. One of the things he said is, in fact, no, there isn't room for everyone on the playing field. And what he meant by that was that girls have been excluded from girls' sports. because of this Connecticut policy. So he pushed right back against the ACLU. He also said, I thought significantly, he said, this case turns on the meaning of sex. And I was so happy to hear him say that. He went on to say that if sex means gender identity in the law, the court should dismiss the case. Now, that was fascinating to hear because
that was a good point.
He's absolutely right. And he's basically saying, look, Judge, if you are saying that sex means gender identity for purposes of Title IX, sure, dismiss our complaint. And then, of course, he went on to explain why, in fact, sex does not mean or should not mean gender identity in the law. And he said basically there are three reasons for this. One is that there's an accepted meaning of sex, which was accepted when Congress enacted Title IX in 1972. It was accepted when the Department of Education promulgated regulations permitting schools to maintain sex-specific sports teams and locker rooms and changing facilities. Right. And it was an accepted reason when Patsy Mink died, and it was renamed in her honor. Everybody knows what sex means. The second reason, he said, is essentially you cannot fit the concept that sex is a spectrum into the structure of the Title IX regulations, which is a very legalese way of saying something that I think is totally true and a really great argument, which is that everybody knows what sex means under Title IX. Everybody knew it then. Everybody knows it now.
We all know.
The concept of a binary does not have any place in the regulatory structure that is built in. And third, he said, there's a reason we have sex-specific sports, and we all know what those reasons are. He went into a little bit of detail. I know that ADF's briefing on this goes into this in a tremendous amount of detail, but it really boils down to the physiological advantages that male athletes have over female athletes. And finally, he concluded by offering a phrase that is near and dear to all of our hearts, which is, this needs to be based on biology, not identity. So I was so grateful to Roger and Christiana, who works with Roger at ADF, for really standing up to what is essentially an assault on women's sports, a legal assault on women's sports and on Title IX. We didn't know if the judge was going to rule orally from the bench. It's very unusual for judges to do that. But
I heard a rumor that might be possible. Yeah, crazy, this case.
Well, it is possible, but it didn't happen. The concern was that this judge is so biased against these girls and against their attorneys that he would just dismiss it from the bench. That was a concern. Even though that's highly unusual, he could have done it. He was within his authority to do it, but he didn't. Instead, he said that we can expect a decision in 2 to 3 weeks.
Which is still a pretty quick decision, isn't it?
I mean, it depends on how much preparation he's already done.
We can leave it at that, huh? I think it was great that Roger led out with reminding us all how Terry Miller, competing in 2017 to 2018, could not even qualify, was not a good enough male to qualify for the state meets. Then the following year was the meet champion as a female, as well as holding records. Like, it does boil down to the meaning of sex. And it's great to hear some attorneys saying that. The truth has amazing power, doesn't it?
Yeah, it does. So yeah, thanks for the opportunity to break that down. I hope that helped. I hope that gave your followers and listeners some information to help make sense of this case.
I think it cleared things up for me some more even. It's great to have you here. I want you to help. Now, this whole ideology is so deep and so connected everywhere. How does this case relate to what's happening with Biden's executive order and gender identity and the Equality Act? Can you kind of break that down for us a little bit? I know it's a hard.
No, a really good way to think about that is to sort of go back to political science 101 and think about, you know, stuff that we learned in school about how there are 3 branches of government. And I'm sorry if it sounds like I'm oversimplifying, but this question is really illustrative of this. There are 3 branches of government, right? There's the executive branch, the legislative branch, and the judicial branch. And so what we've got going on right now in the US is we've got the executive branch dealing with the executive order, the legislative branch dealing with the Equality Act, and the judicial branch dealing with all these cases, including the Soule case, also including the CAIC case, and a couple of other cases that deal with sex and gender. So 3 different branches of government, 3 different mechanisms for figuring out what the law means. So the Biden order only applies to administrative agencies. And it basically says to administrative agencies, go look at your internal policies and your public regulations that concern sex, and come back in 100 days, which is April 30th, with a plan for redefining sex to include gender identity. That's basically what the Biden order boils down to. So presumably agencies will respond to that and come up with a plan to redefine the word sex to include gender identity throughout administrative law. So that applies to things like the Department of Education. It applies to things like, housing and urban development, which oversees federal funding for things like domestic violence and homeless shelters. It significantly will affect the Bureau of Prisons that oversees the federal prison system. It will also affect the FBI, which maintains crime statistics by sex. So that all pertains to administrative law. The Equality Act is pending before Congress, passed in the House this week, and presumably will go before the Senate. We'll see what happens with that. That's a sweeping piece of legislation that would essentially obliterate the coherent category of sex for a lot of purposes throughout almost all of US law. It affects public accommodations, it affects housing, it affects nearly every aspect of US civil rights law. So we'll see what happens with that in the Senate.
So scary.
I know. So,
and that should be soon, right? We're thinking they'll push that on the schedule soon.
They could go anytime. Any day that could happen.
And then can you explain, will that get a hearing? Will that go straight to what's the process with that?
We don't know. Ordinarily, we would expect to see hearings, but we don't know in this instance. The House just went forward with the vote without having hearings. So
technically the Senate would not have to have a hearing to vote on it?
I don't know the specific answer to that when it comes to Senate rules, but I have heard rumors that the Senate may just push this to a floor vote any day, that they have the ability to do that.
Wow.
Yeah. And then the other thing is, one aspect of federal litigation is that it takes forever. So we will have a ruling on the state of Connecticut's motion to dismiss, presumably within the next couple of weeks. I presume that if the judge grants the motion to dismiss, we'll see an appeal. That will go up to the appellate court, which is called the Second Circuit. That will take a really long time. And in terms of how the order, the executive order, or the Equality Act would end up affecting the litigation, it's really hard to say at this point.
Wow. So many different things on different levels, all connected and all threats to womanhood.
Yeah.
This is just, it's just crazy. It's absurd that we even need to wake up and have this battle that we are in. But I am just honored to be by your side in this battle. And I know other women want to stand beside us. I've heard that there is an event coming up soon in DC. Can you tell us more about that?
Absolutely. So after the day after President Biden signed the order, I was talking with a friend and just feeling really awful about it. And I got this image in my head of women standing outside the White House during the suffrage movement. And these women held signs that said, "Mr. President, how long must women wait for liberty?" And I thought, we need to do that. We have the same question for President Biden that the suffragists had for President Wilson over 100 years ago.
Having flashbacks to Iron Jawed Angels, that movie.
There you go. Everyone needs to watch Iron Jawed Angels.
Everyone needs to watch that.
So, I mean, this is where we are. We have the exact same question. Mr. President, how long must women wait for liberty? So I thought, we need to do that. And the friend that I was talking with got really excited. She got right on it. We've spent the past couple of weeks working really hard to put together what I think is going to be a great event. It's called Women Picket DC, and you can go to womenpicketdc.org and check it out, read all about what's going on.
I'll make sure to put the link in below.
Okay, cool. If anyone wants to come to DC for that event, please do. Please consider doing it. You can find the group on Facebook, same thing, Women Picket DC. It's a public Facebook group, and you can get more information there. If you either cannot come for any reason to DC, or you are uncomfortable traveling because of COVID, that's completely understandable. We will be very careful to follow DC's COVID protocols. We're going to be a very peaceful event. And I
was going to mention that it's safe and peaceful, and it's just going to be a good time of women showing solidarity and their strength.
Absolutely. And if anyone wants to support it but cannot come physically, there's a donation button on the website. So it's womenpicket.org. So please consider checking that out. You know,
and did I see you got some merch now too?
We got some merch. We're very grateful to have the endorsement of Save Women's Sports. Thank you, Beth, for that.
I know we'll have some members with flags flying in the crowd. I wish I could be there, but I have an ill parent, but my heart will be there.
Absolutely. And we are so proud to stand in solidarity with you and all the great work that you do, Beth. Really.
Likewise. It's been awesome to have your time. I appreciate you explaining these things, and I look forward to talking more in the future. Good luck at the march.
Absolutely. Thanks so much, Beth. And everyone, keep up the good work. Never surrender.